Good afternoon. Let me first welcome Mr. Young Lee and his family's attorney, Mr. David Sanford, and thank you for joining us here today. After a thorough review of the motion to vacate judgment filed by the previous administration, my office has determined that it contains false and misleading statements that undermine the integrity of the judicial process, which compels myself and my office to withdraw that motion. As prosecutors, our duty is to seek justice and ensure that all legal proceedings are conducted transparently, accurately, and fairly. I must make this explicitly clear. I did not ask for this task. The Supreme Court of the state of Maryland remanded it to my office, and I want to thank Deputies Catherine Flynn, Tom Donnelly, and especially ASA Claire Salzberg, the chief of my post-conviction litigation unit, for taking on this burden. Thank you. We have a duty as prosecutors to pursue justice and as officers of the court to address the false and misleading statements in the state's legal filings, which we take extremely seriously. I did not make the decision to withdraw this motion lightly, but it's necessary to preserve the credibility of my office and maintain the public's trust in the justice system. I'm fully committed to reviewing cases involving wrongful convictions or miscarriages of justice. However, we must do it to the highest standards of integrity and commitment to the truth. It's essential to recognize the complexity and sensitivity of this case. I hope people take the time to understand my office's comprehensive review, the 88-page document, and that ultimate decisions bring closure to all parties involved. How do we get here? In August of 2024, the Supreme Court of the state of Maryland reinstated Mr. Syed's conviction, finding that Mr. Lee's rights as a crime victim representative had been violated by not being provided reasonable notice of the vacator hearing and the rights to attend the hearing in person. This put the ball back in my office's court, so we began an extensive review of the facts, circumstances, and law underlying the motion. First, we reviewed all available documents and evidence related to Mr. Syed's original investigation leading up to his trial in 2000. Second, we reviewed all available documents, evidence associated with the post-conviction litigation between 2000 and 2019. Third, this office attempted to understand the investigation conducted by Ms. Mosby's office beginning in 2021, resulting in the motion filing. What we found during our review: the motion to vacate judgment was predicated on the assertion that the state suppressed or withheld material evidence that would have been favorable to Mr. Syed at the trial in violation of Brady v. Maryland. A Brady violation. To prove a Brady violation, you have to prove two things. One, that there was information that the prosecutors had when they prosecuted Mr. Syed that should have been given to the defense, and that this information was not. Number two, that this information was significant enough that it could have affected the jury's guilty finding of Mr. Syed. The motion to vacate judgment points to two handwritten notes that were allegedly withheld from the defense team between 1999 and 2000, and that alleges that the notes support a conclusion that there were two alternative suspects who could have committed the murder. Our review concluded that the notes did not point to any alternative suspects, and the individuals that the previous administration believed to be the alternative suspects were known to the defense. We also found that the notes were likely disclosed to the defense before trial. Also, even if one of these notes was mistakenly withheld by the state, the notes do not point to an alternative suspect or suspects. One of the notes actually implicates Mr. Syed, and the other note contains information that was known to the state and the defense well before the time of the original trial. The previous administration of motion to vacate judgment wanders afar afield in support of the argument that the state violated Brady by withholding the handwritten notes. They conclude that the lack of confidence is what caused this to have in the original trial. Once we've concluded there was no Brady violation, we technically could stop right there. But we want to address a couple other issues. The motion for vacate judgment attacks the cell phone evidence submitted at trial by adopting the post-conviction court's opinion. Remember, that opinion was reversed on appeal. That Ms. Gutierrez provided ineffective assistance of counsel when she failed to cross-examine the state's cell phone expert on a disclaimer found in the phone records. A review of the trial transcripts and post-conviction proceedings regarding the cell phone evidence demonstrates that the state's cell phone expert was never asked a single question on direct examination and did not rely on the cell phone records at issue in any way. The expert testified that he conducted independent testing on 13 separate locations to determine which cell towers were in the range of those locations and only relied on his notes. This evidence was significant because it corroborated Jay Wild's account at trial of what occurred on the night of Miss Lee's murder, and it showed that the cell phone that Jay Wiles testified belonged to Mr. Syed, but was in his possession while they were together to bury the body, was in fact somewhere in the vicinity of Leakin Park where Miss Lee's body was discovered. Miss Mosby appears to also have relied on the DNA to exonerate Mr. Syed. This justification is problematic for three main reasons. First, the DNA was found in a pair of shoes in Miss Lee's car, and the shoes were never proven to be Miss Lee's. We have found no corroborating evidence supporting the fact that other than the police recovered them in the back seat of the car. Second, there were 4 DNA samples on these shoes. However, Mr. Syed's DNA was not on the shoes, and in fact, Miss Lee's DNA was not on the shoes either. And so this created a question about whose shoes were they, and whether these shoes were the shoes that Miss Lee wore that day. Finally, it appears that the DNA discovered was on the bottom of the shoes, which is unsurprising given that anyone's DNA could be transferred from the ground to a person's shoes. It is critical to note that during this office's extensive review, an email was located from a staffer of the previous administration of Ms. Mosby sent the day before she dropped the charge against Mr. Syed, stating that the DNA evidence recovered from the shoes was not conclusive of innocence. This office agrees that DNA from the bottom of a pair of shoes recovered in the backseat of the victim's car is not dispositive or even relevant to the case. To date, there is no information whatsoever to say that these shoes played any role in Miss Lee's murder. Unlike Miss Mosby, I cannot vacate this conviction based on the lack of Mr. Syed's DNA on the bottom of a pair of shoes found in the back seat of Miss Lee's car. Mr. Syed's case has been one of subject of protracted post-trial litigation, all of which has ultimately resulted in the affirmance of the jury's verdict beyond a reasonable doubt that he is guilty of the murder of Miss Hae Min Lee. While my office has withdrawn the motion to vacate judgment, that decision does not preclude Mr. Syed from raising any new issues that he believes will support his innocence in the proper post-trial proceedings. However, we've now properly shifted the burden back onto Mr. Syed, which will reinstill the adversarial nature of the proceedings that are the hallmark of the truth-seeking function of our criminal justice system. I am hoping and I am very hopeful that this decision will give Mr. Young Lee and the entire Lee family some closure on this protracted process that has caused so much grief to not only you but your family, and will help to restore a sense that justice will prevail in the murder of your sister, Miss Hae Min Lee. And now I would like to turn it over to you, Mr. Young Lee, to say a few words.
2 years ago, system broke. System failed me. I felt betrayed. But thanks to David Sanford and his team, and Mr. Bates and his team, to correct that wrong, fix the system, and give victims a right to say, or give us a voice, give us a chance to say what we need to say. And today, and I also want to thank Judge putting my sister as a true victim of this heinous crime. And let people know that it's my sister who is the true victim here. And I hope that she will make the right decision of denying the reduction of sentence. Thank you.
Thank you, Mr. Lee. And again, on behalf of this office, I would like to offer Mr. Lee and his entire family an apology for how you were treated during this process. And once again, it's not indicative of who this office is. We recognize the hurt and pain that your family has gone through, and we do say we're sorry about that. And now we'll hear from the family's attorney, Mr. David Sanford. Mr. Sanford.
Thank you. Good afternoon, everybody. I'm going to just restate a few things I said in court today because I want the public record to be very clear about some things. In January 1999, Hae-Min Lee was brutally murdered during her senior year in high school. A 6-week trial included the testimony of nearly 40 witnesses with overwhelming evidence of how Adnan Syed planned Miss Lee's murder after Miss Lee broke up with him, strangled her to death with his bare hands, and enlisted a friend to help dispose of the body in a shallow grave in a local park. A jury convicted Adnan Syed of first-degree murder, kidnapping, robbery, and false imprisonment. The court sentenced Mr. Syed to life for murder and consecutive term sentences for the other felony crimes. Mr. Syed remains a convicted murderer to this day. Absolutely nothing, not a popular podcast, not an HBO documentary, not worldwide press coverage, not the support of Mr. Syed's family and friends, not the state's wholly unsupported motion to vacate, not the cultural hysteria surrounding this tragic matter, and not the zealous and compassionate defense by Mr. Syed's experienced legal team changes the essential fact that Mr. Syed remains convicted of premeditated murder due to overwhelming evidence that has stood strong against creative legal challenges and extensive public comment. I'd like to say a few words about the motion to vacate as well. In 2022, the state of Maryland filed its motion to vacate judgment, claiming that the state no longer has confidence in the integrity of Adnan Syed's conviction. The state further contended that it's in the interest of justice and fairness that these convictions be vacated. The vacature statute was designed to give relief when new information is produced that calls into question the integrity of a conviction, or when there is newly discovered evidence that undermines the trial result. Transparency was denied the public and denied the victim's family when the state engaged in private in-chambers proceedings without a court reporter and without evidence presented on the record. Transparency was denied when the circuit court failed to conduct an evidentiary hearing, which it was required to do, and failed to provide findings of fact and conclusions of law in support of overturning a unanimous jury verdict. And most significantly for Hae-Min Lee's family, it opened a wound that had been in the process of closing for over 2 decades. However, transparency was achieved last night when the state of Maryland announced that its motion to vacate judgment, filed by the Maryland Mosby team and initially granted by the circuit court, and I'm quoting here, contained false and misleading statements that undermine the integrity of the judicial process. It wrote further that there was outcome bias in favor of a conclusion that Mr. Syed was innocent or at least wrongfully convicted. As a result of this finding, the state last night concluded that we have no choice but to withdraw the motion. This puts to rest the idea that there is new information that calls into question the integrity of Adnan Syed's conviction. Today was an important day because it was the day after the state corrected the record. And the day after the state corrected the record, we held a hearing in court, which many of you attended. And at that hearing, Adnan Syed is asking the court to reduce its sentence of him to time served, essentially, allowing him to remain free from custody. We oppose that motion on behalf of the Lee family. And the reason we oppose that motion is because the statute requires that a court consider 11 factors. And based on our representations, 7 of those factors are failed to be met by Mr. Syed. Not only does he fail to meet 7 of the 11 essential factors, but he has never to this day expressed remorse. He has never to this day accepted responsibility for the crime he was convicted of. And it was interesting today to listen to the witnesses who testified on behalf of Mr. Syed, because they talked, I thought, movingly about their experiences with Mr. Syed in prison and out of prison. But not one person Not one mention by one person about a conversation they may have had with Adnan Syed, where Adnan Syed expressed sadness or any remorse or any regret or any pain associated with the death and murder of a loved one, of someone he dated, someone he allegedly physically intimate with, someone presumably he loved. Not one mention of that in hours of testimony today. And I think the failure of that speaks volumes. It speaks as loudly as does the fact that Adnan Syed never called Heyman Lee after the murder. Many people knew she was missing, and the cell phone records show that many people tried to reach her. But not one call from Adnan Syed, who had called her numerous times the day before, but never afterwards. There's a lot in the record, and when you through the record, you find overwhelming evidence of guilt. The jury found overwhelming evidence of guilt. The judge, in an extraordinary, issued a declaration in this matter saying there was overwhelming evidence of guilt. And nothing that Adnan Syed has ever done, nothing that his legal team has ever said or ever produced calls that into question. And it's for that reason that we oppose the motion to reduce sentence, and it's for that reason we hope the judge will agree. Thank you.
I guess at this moment in time, I'll go ahead and open up for any questions.
All right.
Are we calling on?
I'm about to say, yep, you can go ahead.
Mr. Bates, Blair Sable with WMAR2 News. Can you talk a little bit about the timing with withdrawing the motion last night? I mean, it's very interesting. It happened right before this hearing. Was that on purpose?
Well, this is what I will say. When we had the opportunity to speak with Mr. Lee back in 2023, the summer of 2023, Mr. Lee had a lot of questions. We had a lot of questions. Then when the court issued the mandate to look at the case back in September, it took a couple months to get the files and to look at it. Our entire goal, and we saw the filings, is that clearly Mr. Lee, Stanford, they wanted to have an understanding of where we were going to be before we had the hearing. We only thought that was fair. However, we blocked out the noise, and we had to focus on every single thing and look at it as if it was brand new. Now you have, once again, as I explained, you have the pre-trial and the trial. So from the time the incident happened all the way through the trial, the transcripts, the discovery, all that. Then we have to look at the post-conviction. There's a number of transcripts and court proceedings to that. And then we had to look at this. So it took a while. We wanted to make sure, because we've made some pretty strong opinions known and viewpoints known in the filing. So we wanted to ensure that we got it right. And that just took a while. We did everything we could. I cannot thank the team that you see up here enough for the hard work and dedication they put in. I mean, we put a lot of work in there. So to answer your question, we wanted to do it before the court hearing so that everybody knew where we were. It was one of the things I think Mr. Sanford strongly wanted to have happen in his filings. He wanted to know what was going to be the state's stance, and we did everything we could to get it so that the world would know before we started that court date.
Todd Carpenter's Baltimore Sun. Did you expect the judge today to kind of not make an immediate decision, kind of take more days to kind of go over the evidence?
Well, I did in the sense that the statute says you have to have a written opinion. So I did not suspect that she was going to have a written opinion today. In that regard, there's a lot of material, a lot of information, a lot of things that she's going to weigh. And, there's a lot of material that they're going to go through as well. And so I did not necessarily expect the judge to necessarily make a ruling from the bench.
Do you know if the withdrawal of the motion to vacate can be appealed, or is that a done deal?
No, it cannot be appealed. It's a done deal. It is the state that brings it and the state that decided we will not proceed with it.
You're round two.
Sorry. Do you have full faith in the case as it was laid out by the original prosecution, just based on where we're at this point?
I have 1,000% faith that the jury listened to the evidence and the jury said guilty beyond a reasonable doubt because that was the evidence. So yes, I do have full faith in the case that was presented to the jury.
Okay, anybody else? Oh.
Hi, for question for although they applauded the decision that you made yesterday, Heyman Lee's family expressed frustration that you were supporting Syed's
Well, without a doubt. I mean, look, he lost his sister. The mother lost her daughter. You know, they definitely, without a doubt, want to make sure that this gentleman is held accountable. And so from my standpoint, I get that 1,000%. But I also have to look at it, what does justice mean to everybody else as well? Because, you know, I deal with a lot, unfortunately, of victims and the family members. So I have to find out where that balance is. So today I tried to articulate why we said that we supported it. You know, we see, unfortunately, more and more young people committing violent acts. And so we want to try to make sure we treat everybody fair. And where within that process, and also looking at second chances. I've been a strong advocate to say I don't believe in warehousing individuals. I believe in second chances. But without a doubt, Mr. Lee, his family, his attorney, they're entitled to their feelings. And if it was my loved one that I lost, I'd feel the same exact way. So I definitely understand that. I try to be as respectful and sympathetic as possible, especially because Mr. Lee has not been treated very fairly at all by this office or the system. So I'm very mindful of that. But I also recognize that I have to make sure we do and treat everybody the same way. There are other individuals who didn't have the background and record of Mr. Syed, and we've said no to. There are other individuals that did not necessarily have the same time period in that we've said no to. So for me, it's making sure that we look at everybody and treat everybody as fair as possible. And that's what this is in our respect.
Presidente, do you think there are going to be implications for innocence work going forward from this episode? I mean, you're saying that your predecessor misled the court to let Adnan Syed out of prison. What does that mean for the cases that come back up, the next one?
Well, I think when you deal with vacators, like earlier this month, we vacated a gentleman who had 30 years in prison, and it took us almost 5 years investigating that very thoroughly. We spoke to the victim's family, showed the victim's family all the evidence, and they realized, like, oh my goodness, the wrong person's been in jail for 30 years. I think what it says is that as the state, when we bring a vacator motion, we have to have our P's and Q's. We have to dot all our I's, cross our T's. We must get it right. One of the things that I look at entirely the way in which, like Mr. Sanford said it best, this motion wasn't done out in the public. There was no transparency. So you really don't know enough for, you know, I think our motion, our brief that we put together, it talks about, you know, the note and not speaking to the prosecutor. You know, if that's the case and we feel that way, then our office would need to put the prosecutor on the witness stand to ask the prosecutor what the note said. Our office would need to put the witness on the witness stand if we know the witness who called in to talk about the note in terms of what it was said. That's part of the transparent process of an adversarial system. And that was not done in this vein. We need to make sure we do vacator motions, that everybody has to be on the same sheet. And for us, it was very important. A young man whose case we vacated, we spent 5 years investigating that. And once again, if we had the evidence, and Mr. Lee said, if we had the evidence, we went to him and said, this is the evidence that we have, then I have no doubt that if it was strong evidence and it was the evidence that pointed to innocence, that Mr. Lee has already stated he does not want the wrong person in jail. And we did that in the other case that we had, and the family was very upset that this man had spent 30 years in prison when he should not have.
Ms. Bates, Kevin Richardson with the Baltimore Sun. Did your office talk to some of the previous witnesses during the first trial, or did you all work off the transcript for the public decision that you had?
We worked off the transcripts, but you know, we talked to other witnesses in terms of the different things. For instance, we spoke with Mr. Yerk, who was the prosecutor. We not only spoke with Mr. Yerk, we spoke with the other assistant state's attorney, Ms. Casey Murphy, who was working on the case with Mr. Yerk. So we talked to the other individuals who also were involved in the vacator process as well, some of which were in the state's attorney's office, some of which were in the Baltimore City Police Department. We made sure that for us to get it right, we had to speak to the individuals that had the information that we needed. And therefore, we wanted to be as transparent as possible. And that's why you see an 88-page document.
And just a critical note, the review that he is talking about today only looked at the motion to vacate. It did not look at the original trial. So he is, they examined the motion to vacate.
That was all, just the motion to vacate.
Yeah, a couple of years ago, we were in this room with Marilyn Mosby announcing that this was over. Both she and Becky Feldman had talked about investigation that was going to happen going forward, and I noticed in your filing yesterday, you were saying there was no investigation. Can you just talk a little bit, like, what happened between 2022 in terms of looking more into any new leads, any new information, and now? Are you saying, like, nothing happened?
Yeah, I can't talk about what happened anytime until January 3rd, 2023, when I was sworn in as state's attorney. What I can tell you is that we had the opportunity to speak with a couple of the police officers who were given a couple of tasks. They performed those tasks and they've never followed up. I can tell you we spoke to other members of the state's attorney's office that were given one or two small tasks. They were given those tasks and no one ever followed up with them. So there was, from what we view as, no investigation. There were no additional tasks. There were nothing at all. So once again, we don't feel that there was ever an investigation. Our office is not opening an investigation. We feel the jury looked at the evidence, and based on the evidence, they ruled beyond a reasonable doubt that he was guilty.
Can you talk at all about what those tasks were that the detectives and the state's attorneys did?
We interviewed Baltimore police. We interviewed some of the prosecutors in this office. There were no tasks given that the police felt went to the murder of Haymon Lee. The tasks they were given, which they ultimately refused or pushed back on, were tasks to investigate people, not a crime. And there are prosecutors within this office that were told they were part of an investigation, but never given any guidance on what that investigation would entail. When we arrived at the office, we interviewed everybody we could to figure out what was going on, and what we found is not much, nothing. So.
Chris with WBAL, kind of following up on the question about the witnesses, and I know you had mentioned you took it over from when you became state's attorney, but from the Serial podcast, Jay Wiles was a big time name. Was he found? Was he talked to with developments with this? Anybody else from these media outlets that kind of gained notoriety a couple of years ago?
We didn't go to reinvestigate the murder. We looked at the motion and we reviewed the motion to vacate. And one of the things that's very important. So the way the motion to vacate works is this way, and the way it should work is this way. We have to go ahead and investigate it and we had to review their investigation. Once we reviewed their investigation, if we felt there was information that was a Brady violation and we believed in the motion to vacate, then I would be putting my name behind that, and then we would put on the evidence. And so we did not see it that way, and we were not going to put our name behind that. And we were only reviewing the motion to vacate. The jury has already spoken. There's no need to reinvestigate this case. There's no need to do anything like that. If the defense feels that way and they have new information, they can bring it to us and we can look at it. We can do whatever we need to. But in terms of where we are right now, this very second, the jury spoke 25 years ago, and there's been nothing yet that's changed that.
Got time for two more. Anybody?
Can you talk more about why you're not opening a new investigation at this point?
Well, because for us, the jury listened to the evidence. For instance, Jay Wiles was on the witness stand for almost 5 days. 5 days. They heard let me tell you, having been a former criminal defense attorney, I can tell you Christina Gutierrez did a phenomenal job in her cross-examination, and she did an excellent job. The jury listened to the evidence. The state put its case on that corroborated a number of things that Jay Wiles said. And the jury felt that beyond a reasonable doubt that Mr. Syed was guilty. And for us, there's no need for us to go. If we did that, we'd be doing it every single time the jury said guilty beyond a reasonable doubt. It is now upon the defense, if they have new information, to bring it to us. It's not for the state to go looking for new information on cases where the jury has listened to the evidence, and as a goal, they've sat down and said beyond a reasonable doubt. It's hard to get guilty verdicts beyond a reasonable doubt. It was a circumstantial and direct evidence case. We could even look at I think it's the Supreme Court of Maryland, I think it was Court of Special Appeals back then, where they said there was circumstantial and direct evidence that was.
The Supreme Court of Maryland.
Supreme Court of Maryland looked at it.
Substantial, direct, and circumstantial evidence.
Substantial, direct, and circumstantial evidence is the exact wording from the case that their opinion that they had. So I think it's very important to recognize they've already spoken, and we're pretty busy here in Baltimore City with a number of other cases.
Get the last one.
Oh, thank you. Sorry, this is sort of a technical one. The two cases that, Mr. Sanford, you mentioned today that are now before, is it the Supreme Court of Maryland?
Montague and Trimble.
Can you, Ms. Suter was saying actually those don't really apply, or they won't be definitive in some way, so like we don't need to wait for them. It seems like you were asking maybe the judge to wait. Can you guys just talk a little bit more technically about what those cases are and why you think they matter and why you maybe think they don't at this juncture?
The court can do what the court wants to do. If the court wants to rule early before those cases, we would be fine with that. I simply suggested that it might make sense to wait because the court could be informed from the Maryland Supreme Court about the standards that should be applied. There are two cases, one involving the age of the person committing the crime. So in this case, Adnan Syed was a little over 17 and a half years of age. Question is, in order to avail yourself of the statute, you have to be under 18, so we know that. But one of the enumerated factors is also age. So what does that mean? We say that means that there's a difference between committing a crime when you're 14 and committing a crime when you're 17 and a half. And a judge may weigh those two cases differently, may view a 14-year-old's crime as being perhaps an extenuating factor given the person was 14, more so than if a person's 17 and a half. Supreme Court is going to rule on that very issue sometime this term, sometime within the next 6 months. So we said it might make sense to wait on that. The other issue is Montague, which concerns remorse, whether or not an offender needs to express some remorse in order for there to be a favorable disposition in a request for a motion to reduce. That issue is squarely before the Maryland Supreme Court as well. So there are 11 factors. 2 of the factors are in question as to how a court should weigh them, and the court may decide to wait, may decide not to wait. It sounded from my ears that she may be ruling sooner than the Supreme Court.